A federal appeals court decided yesterday that President Trump does not have to rip up his tariff playbook for now. It temporarily paused a ruling by the Court of International Trade, which determined on Wednesday that Trump did not have the authority to impose most of the economy-shaking tariffs he's unveiled since January. That included his sweeping Liberation Day blanket tariffs of 10% or more on virtually all foreign goods, as well as additional duties on Canadian and Mexican imports, all of which Trump introduced under the International Emergency Economic Powers Act, IEPA. The White House is expected to ask the Supreme Court to decide whether this was fair game if lower appeals courts don't ultimately preserve the tariffs. But even if Trump loses, tariffs aren't over. White House trade officials have derided the tariff-foiling decision by the Court of International Trade as a minor hiccup caused by activist judges. They insist that using the IEPA to implement tariffs is just Plan A, and Trump has plenty of other, albeit less powerful, legal options to impose duties. Federal law allows Trump to impose tariffs of up to 15% for up to 150 days in situations where imports exceed exports to a degree deemed a crisis. He could also use a legal provision called Section 232 to impose industry-specific tariffs following an investigation into how imports affect national security, as he's recently done with steel, aluminum, vehicles, and auto parts. And then there's Section 301, which allows the president to investigate a country for abusive trade practices, a rule he leveraged to put tariffs on China during his first term. But experts say that the uncertainty surrounding whether Trump's current tariffs will pass legal muster might push some countries to adopt a wait-and-see approach to negotiating trade deals with the U.S. The Trump administration is currently in high-stakes talks with key economic partners, including the EU and Japan.